As you may know, Asian Americans Advancing Justice is a national affiliation of 5 leading organizations advocating for the civil and human rights of Asian Americans and other underserved communities to promote a fair and equitable society for all. The affiliation's members are Advancing Justice AAJC in DC, Advancing Justice Asian Law Caucus in San Francisco, Advancing Justice Atlanta, Advancing Justice Chicago, and Advancing Justice Los Angeles. Our speakers today will dive into immigration executive orders and related lawsuits, the federal budget and funding, enforcement, and state-level policies and community responses. After the presentation, we will open it up to Q&A. When we start Q&A, if you'd like to ask a question, you can go to the webinar toolbar and use the question function or chat function. So let's get started. Angela, can you hear us?
This is Angela. Would you like me to get started? Yes, I can hear you. Okay, just making sure. Hi there. My name is Angela Chan. I'm the Director and Senior Staff Attorney at Asian Americans Advancing Justice, Asian Law Caucus located in San Francisco. And I will be covering the sanctuary jurisdiction executive order litigation, and then later on I'll talk about some models of resistance coming from California. So for the sanctuary lawsuit, San Francisco and Santa Clara, both of these counties sued the Trump administration seeking to stop Trump's January 27th executive order on interior enforcement, specifically Section 9A, which threatens to withhold federal funding from so-called sanctuary jurisdictions. And the way that the executive order defined sanctuary jurisdiction is that any jurisdiction that willfully refuses to comply with 8 U.S.C. 1373. 8 U.S.C. 1373 is a federal statute. It is very narrow. It specifically limits a restricting of sharing of information regarding an immigration status. So basically, a county or a state could not enact a statute that would say you're not that city employees or state employees can't share information about immigration status or citizenship with ICE. That would be the specific type of statute that might violate 8 U.S.C. It's important. Federal statute is very narrow. It does not prohibit limits on ICE holds. It does not prohibit some ICE notification requests, and it does not limit on inquiring about immigration status. Basically, review most pro-immigrant legislations out there, so-called sanctuary ordinance legislation that in San Francisco, Santa Clara, and many other counties throughout the country, you would see that they actually do not violate 8 U.S.C. 1373. And so that's kind of just important to note. San Francisco and Santa Clara argued specifically that the executive order, the Section 9A, is coercive and that it violates the 10th Amendment of the Constitution, which prohibits the federal government from basically requiring or commandeering local and state jurisdictions to execute a federal program. And so that's their in this case. Next slide, please. Next slide, please. Okay, and this is a court decision that recently came down on April 25th. It's coming from the Federal District Court in the Northern District of California, Judge Orrick. He issued a preliminary injunction, and the injunction is a national and against that specific section of the executive order. It stops the executive branch from placing new restrictions on federal funding without first going through Congress. And so this is new restrictions. It does not impact the federal government's ability to use lawful means to enforce existing conditions in federal grants, and it does not prevent the federal government from enforcing 8 U.S.C. 1373. And so what that means is that there are basically 3 grants that already have a condition regarding compliance with 8 U.S.C. 1373. Those 3 grants are SCAP funding, JAG funding, and COPS funding. So those 3 fundings can still be conditioned on this compliance. However, because the federal statute is so narrow, really most jurisdictions don't have to worry about this. And I think some folks might be asking about the recent letter that was sent from the Department of Justice to about 9 jurisdictions asking for a certification that they are complying with this statute. The Asian Law Caucus is drafting a sample response that jurisdictions can use to reply to it that would explain why your jurisdiction's policies do not violate this federal statute. The decision on the executive order regarding sanctuary ordinances also does not restrict the ability of the secretary to develop regulation to as a sanctuary jurisdiction, but that's all they can do is just designate a jurisdiction as such. They can't take further action to withhold federal funding that doesn't already have these existing conditions. And again, most jurisdictions comply with the existing conditions in these limited grants. And then next slide. I'll pass this on to my colleague, Alifi.
Hi, can you hear me?
Yes.
Okay, great. Thank you so much. Just doing a sound check there. So I'm here to cover the Muslim ban. And, you know, this is a National Week of Resistance. And the reason why it's a National Week of Resistance is there are actually 2 cases happening at the appellate court level, one in the 4th Circuit in Maryland that just happened this week, and one at the Ninth in Seattle that will happen next week. But taking a step back quickly so that we can understand what happened and why of resistance, and you know how we kind of got to this point, I just wanted to summarize quickly the executive orders and what has happened with the litigation. So, you know, taking a step back again, throughout this administration campaign, very intense anti-Muslim rhetoric, anti-immigrant rhetoric, you know, promises that were highly Islamophobic around banning Muslims, around registering Muslims, that really caused a lot of concern and anxiety and backlash in our communities. Then on January 27th, this administration delivered on the campaign promise to ban Muslim immigrants through an executive order. That executive order was implemented immediately on the spot, and it basically said that certain immigrants from 7 Muslim-majority countries, Iran, Iraq, Syria, Sudan, Libya, and Somalia, as well as Syria, would not be able to enter the country for a period of 90 days. That period of 90 days could then be extended beyond that time if the administration deemed that that would be appropriate. The second piece was a complete halt of the entire refugee program, regardless of what country you come from, for 120 days, as well as an indefinite halt of admitting Syrian refugees into the United States. Another aspect of the program was also looking at what additional screenings and information needed to be asked from individuals from these countries throughout the immigration process. Because the executive order was implemented immediately, and there was no kind of way in time for that, what happened was several individuals, including green card holders, were detained at airports. The executive order was signed, and they landed after it was in place. So what we saw was hundreds of people being detained at airports, not being able to come back in to be with their families or to visit family and friends, pursue educational opportunities, etc. And that's when we did see, as I'm sure folks know, really the large turnout of protests and and community ethical support. We also saw that visas were revoked. Folks were coerced into signing away their green cards, and it was really egregious. As a result of that, the litigation that filed first in New York, then the other major cases in Washington to put an injunction on the entire executive. So really saying that, you know, through the injunction that the court needs to pause this program before it can move forward, because it's causing such a large injury to the community that the court should really consider the legality of the executive order. Then what happened was the injunction was granted, first in New York for individuals who were stuck at the airport. And then, of course, as folks know, through Washington, the entire program under the executive order was put on what we call a temporary pause through an injunction. Subsequently, it was appealed to the Ninth Circuit Court of Appeals, which upheld that the injunction could stay in place. And rather than continue to appeal it, this administration decided that they would essentially rescind the first executive order and issue a second executive order that would be in effect. They said that they claimed that the second executive order would take care of the quote-unquote issues in the first one. They tried to make some minor facial changes. They removed one of the countries, Iraq. They removed the indefinite pause on the Syrian refugee piece. And they also added some waivers and an implementation period. Unfortunately, trying to make a few minor facial changes doesn't change the fact that it is devastating to our communities and unconstitutional and highly problematic. And so what we saw was on the day that the second executive order was supposed to be to go into effect, we saw that Hawaii stepped up and came forward and was able to get another injunction on that on the second executive order, so it kept it from being implemented. So that's kind of the complicated lay of the land. It's the roller coaster, you know, of these executive orders. And so the National Week of Resistance highlights the Hawaii case, again, which is coming up this Monday, the 15th. And, you know, the Court of Appeals will be hearing that. And then this past week, a case in Maryland that was heard by the Fourth Circuit Court of Appeals as well. And so what we're really seeing is, you know, this issue working its way through the court system. Because of the injunction, there is a temporary pause, but we really need to be mindful of the fact that these executive orders have not been fully struck down. And so it's requiring a lot of education and outreach in our communities, a lot of know your rights information, and also being very mindful of other ways that the administration may be trying to help Muslim immigrants and folks from Muslim majority countries from being able to come to the United States, you know, to be with their families and for educational purposes, etc. There's a great, you'll see on the slide, there's a great link there to the National Week of Resistance and ways to get involved. So I'll stop there, but happy to answer questions. Thanks.
Hi all, this is Megan Essahab with Advancing Justice AAJC. So Chris and Aki are going to talk more about the human effects of this administration's mass deportation agenda, but I just want to run quickly through what I think is the most important point of resistance in Congress against Trump's mass deportation forces, and that is government funding. It's really the only real impact that at least congressional Democrats can have in slowing down his mass deportation force, because Trump has promised to hire 5,000 additional Border Patrol agents and 10,000 additional ICE agents, and he's going to need a lot of money to do that, as well as more money to increase detention space and just for things like transporting people, and actually enacting the deportations. And then, of course, he's also trying to build a $20 billion wall. So we encourage folks to tell Congress to oppose funding for the wall, any agents, and detention beds. So just to run through the last funding fight, the bill passed actually before April 30th, but there was a compromise bill. It was a partial win because the White House had asked for $5 billion additional dollars over the $20 billion that we already spend of taxpayer money on immigration enforcement, and Congress gave them $1.5 billion in immigration enforcement, so it was an increase.
which is bad, but not completely what he asked for. And there was no money specifically for the wall or hiring additional agents. There was money for additional detention bed space and some kind of HR money for hiring. So, you know, we saw this as like battle one and a long fight that's going to happen over and over again. The next time it'll happen is September. On the success side, Senator Harris, Senator Cortez Masto, Senator Booker, Representative Chu in the House, Representative Jayapal, and many members of the Congressional Hispanic Caucus were helpful in weighing in with leadership, but we really need to grow that base of champions who are going to stand up against funding the mass deportation force. So the next fight will be, the government is funded through the end of September. There'll be a lot of talk about appropriations or funding the government over the summer, but most likely they'll be last minute in coming to a deal to pass the spending bill. We expect this time the White House is going to ask for a lot more money to really start hiring more immigration agents and building the wall. And so I encourage folks to, every time they meet with their member of Congress or their senators, to raise this as an issue that you want them to oppose any, you know, you could say you want them to defund the mass deportation force and decrease detention beds. And so just people can contact me if they have any questions. I will be reminding you about this over and over again. I guess one other takeaway was just that first of all, under Obama, we should have been pushing harder for Democrats to reduce the amount of funding going to immigration enforcement. And most of our targeting was on President Obama. Most of the asks in Congress were for comprehensive immigration reform or a path to citizenship. And so you kind of have to take a step back and start at square one and connect the dots of, you know, the pain that's happening in communities and the deportations and the detention that's happening to the government funding, and really do a lot of education work in a lot of offices.
All right. Hi, everyone. My name is Christopher Lepinig, and I'm a Skadden Fellow and Registered Legal Services Attorney at Advancing Justice LA. So I'll be talking about immigration enforcement under this new administration. So in addition to the troubling raids that took place in February, we're continuing to receive reports about enforcement actions throughout the country, including actions targeting AAPIs. So I briefly just wanted to flag for you two cases. I'm not going to say too much about them here, but I encourage you to read the news coverage about these cases if you're interested. So the first example comes out of New Jersey, as you see on this slide. So 4 Indonesian men they had voluntarily registered with NSEERS, which is a federal program that was largely used during the Bush administration to target Arab and Muslim men. They were recently taken into custody when they appeared for a check-in with ICE in Newark, New Jersey. And you know, the affiliation has long been troubled by NSEERS, and unfortunately this case suggests that profiling and abuse through this program may be starting anew. So next slide, please. The second example is Gurmukh Singh out of Orange County here in California. We've been fighting for years to stay his deportation, and he applied for asylum back in 1999, but has been, for various reasons, facing removal for some time. And recently, as this report shows, he was recently returned to immigration detention. Next slide, please. So overall, what has changed since this administration has taken office? So here's a reminder of what immigration enforcement priorities look like during the final 2 years of the Obama administration. So generally, the Obama administration made clear that it was prioritizing enforcement against individuals with significant criminal convictions, recent deportation orders, or recent entries into the U.S. without inspection. Next slide, please. But on the other hand, this new administration has taken a completely different approach. So as you can see here, there are a number of troubling issues with how they've articulated their priorities. This administration's quote-unquote priorities don't really rank the priorities at all, as the Obama administration had done, and nor do they define what types of criminal offenses would make an individual an enforcement priority. So, what's worrying is that the administration has said it will target individuals who have been charged with a crime, even if they have not been convicted, and even individuals who have allegedly committed a crime but have not even been charged. And another thing is that this administration strategy is silent on whether recent removal orders or recent entries into the U.S. without inspection would be prioritized over older ones, as the Obama administration had made clear. So all in all, in other words, ICE seems to have more discretion under the priorities by this administration, and as we've already begun to see, this latitude may be leading them or encouraging them to apprehend quote-unquote low-hanging fruit. Next slide, please. So we've already begun to see the effects of these new priorities. So from January to mid-March of this year, compared to the same period last year, almost all of the ICE field offices across the country have seen immigration arrests, with a total nationwide increase in arrests of 32.6%. And this includes doubling of the number of arrests of individuals without criminal convictions. Another thing is that it seems to be collateral arrest than it did under the Obama administration. And in other words, whereas under the last administration, ICE agents were generally only arresting the particular person they were looking for, now it seems like they're also arresting other non-citizens of the way. Next slide, please. So here's a chart from the Washington Post just showing the increase in arrests in absolute numbers from January to March of this year compared to the same period last year. Next slide. So the last issue I want to talk about is sensitive locations. So back in October 2011, ICE issued a memorandum stating that it would limit immigration arrests at certain sensitive locations, including schools, hospitals, and places of worship. And this administration has not formally revoked this memorandum. However, courthouses were not included in the memorandum from the beginning, but the Obama administration did have a policy of only using courthouse arrests as a last resort if it couldn't apprehend someone that they were looking for through other means. By contrast, this administration has turned that practice on its head. So not only has it rejected calls to halt courthouse arrests, it's actually stated publicly that it now prefers these types of arrests, as it believes that courthouses are safer environments for ICE agents to apprehend individuals they're looking for. Next slide. So all of this is worrying, and Advancing Justice is working with its partners to determine potential interventions, whether legal or policy or otherwise, to curb this practice. In the meantime, however, here are some practical pointers for advocates who have clients who might be vulnerable to courthouse arrests. As much as court, of course, ideal. If your client does have to go to court, we encourage that you have them remain within courtrooms rather than public areas, and also try to avoid situations where their name is called out loud. If you suspect that ICE is present in the courthouse, you should alert judges, the judge in your case, or court staff, as well as your client. And your client should be aware that she has the right to remain silent and to leave the premises unless formally detained. If ICE does try to talk to your client, you should identify yourself to them as the attorney and have them direct any questions to you. Don't identify your client or answer any other questions. If they seek to arrest your client, ask to see a warrant or any other documentation they might have. To the extent you can, take notes about the arrest and document it, and advise your client not to answer any questions or sign any forms. After an arrest, you should inform your client's family and also contact any appropriate networks, such as RAID's response networks in your area, nonprofits, and if applicable, any consulates. So next slide, please. So the last thing I'll just leave with you with are just some additional resources for your reference. But now I'm going to turn it over to Aki from the Filipino Workers Center here in LA, and she's going to discuss a recent example of deportation that illustrates this administration's approach to immigration enforcement.
Hi, thank you. Recently, one of the first cases that we've encountered where a Filipino immigrant has been picked up at his house occurred to Ray Galion, and he is actually a former crew member who, when his ship was docked here in the harbor, went aboard and basically went off the ship to the mainland and did not return. So since then, he's been here for just over 10 years. He has a wife, he has 2 citizen children, and one day when he was coming back from dropping off his oldest, and both of his children were born here, both U.S. Citizen children, when he was dropping off, after he dropped off his oldest child to school, came back home, and when he heard people outside looking, talking to neighbors, looking, mentioning his wife's name, he went out to talk to them. More recently, it seems like it was not actually ICE, but it was CBP who picked him up, and there were CBP, Customs and Border Patrol officers who were there, and they asked him if he was Ray Galion, and Ray is actually a former AFW member until 2015 when he had moved away. So he hadn't been connected to kind of the latest know your rights information, what to do, what not to do. So he was just trying to be very cooperative, and he was also being very protective of his family, his wife, who also did not have documents, and cooperated and was right then and there picked up by CBP and brought to the Long Beach office. Throughout the day, he asked to be able to call his legal assistance or to call an attorney, but he was repeatedly denied, and he also was not allowed to use his cell phone. They gave him a lot of false information, saying that his only choices were either to sign a voluntary departure form, buy his own ticket, and go back to the Philippines, or to be put into jail for at least 6 months. He did not know about his rights, that he could be, let out on bond to fight his case. And he thought that he would be going to jail, like a regular criminal jail. So the officers made it sound like they were doing him a favor, and so he ended up signing the voluntary departure and buying his own ticket, and within, by 10 o'clock that evening, they escorted him to the airport, where when he was at the airport, that's when he was allowed to call his wife, and then he was escorted onto the plane and flew home to the Philippines. After he was in the Philippines is when he actually was able to reach out to PwC to assist him and his family. We don't know how many others are being also. There could be others who are also, sent home in this manner that we just don't know about. But we do know in consultation with like the consulate that what they have definitely seen is an increase also in the processing of travel documents for those that already have deportation orders. And that has definitely increased. We also have seen part of the impact of this increasing enforcement and fear has also been an increase in members in our community looking for solutions and there are many who are falling for things like asylum scams, where they don't actually have an asylum case but are told that this is a legitimate way to get a green card, or just working authorization. And we also do see there are folks who have ICE check-ins, and we're working with them to try and prevent them also from being detained, and to make their to try and get their stay of removals approved as well. And we're not only bringing together legal support, we've been definitely building up our deportation defense. We are having legal clinics that also include Know Your Rights workshops that are not just about presenting information, but also a lot of role playing, as well as incorporating healing circles to deal with the stress of what's happening. And then we're also building a larger network that we're calling the Sama Sama Network, to really call the whole community to stand together with our immigrants and refugee communities, and also with our all of our brothers and sisters who are under attack also from hate crimes and discrimination, like the Muslim community as well. We are developing legal fund support, as well as rapid response networks within the Filipino community, but also the worker centers are building rapid response together as well. Thank you.
All right. Hi, everyone. My name is Aisha Yaqub. I am the Policy Director with Asian Americans Advancing Justice in Atlanta. I just wanted to go over some of the resistance models that we kind of work on in Georgia, but preface it with just explaining the things that we're dealing with in the South. So, for a lot of the country, we are right now seeing a lot of hateful policies from the federal side, but in Georgia, we've been used to it for quite some time. Some of the state level policies that we've seen this year are going a bit further than we've seen in recent years. Literally right after the election in November, within a week, we saw a bill that was trying to ban, they called it the burqa bill, that was trying to ban Muslim women from being able to cover their face, to wear niqab. Thankfully, with our advocacy groups that we have, we were able to kill that bill pretty early on, even before the legislative session started. But it was just a signal that there was going to be a pretty crazy legislative session. We just actually finished the session at the end of March, so I was going to go over some of the bills that we were fighting and that we're still fighting right now. So, in past years, we have been fighting driver's licenses bills that are targeting either undocumented people or non-citizens in general, but this year in particular, they were targeting all non-citizens. So essentially, they were trying to mark all non-citizen driver's licenses with, non-citizen written in big red letters. Our strategies for fighting some of these anti-immigrant bills really have come from our support within the business community. A lot of our business leaders came up and said, I have clients and I have business partners that are not citizens because they're from other parts of the world, and I don't want them to look badly upon the state of Georgia because they're trying to label them differently. That was our big support when they came to those driver's licenses bills, because those were broad enough to get the support of the business community. Some of them are a little bit tougher to get businesses to sign on to. Another one that the businesses really helped on was the remittances bill, which was trying to tax wire transfers outside of the state, but then also outside of the country. And so we figured that one was definitely going to impact our immigrant communities, because we already know how many of our community members frequently send money outside of the state and outside of the country to their families back home. Now, the two bills that we fought but unfortunately did not get killed and did get signed into law was the anti-sanctuary campus bill and then the non-citizen registry. So the anti-sanctuary campus bill came this year after last year's anti-sanctuary city bill got passed. And so this was obviously in response to some of the rhetoric that's been happening around the country, but primarily because Emory University, one of the large ones here in Atlanta, had said that they were looking into becoming a sanctuary campus. Now, within weeks of that announcement, the legislature had introduced this bill that would restrict state and pass-through federal funding to private universities that enact sanctuary policies. Now, the bill here, we fought it for quite some time, and we got some support from the universities themselves. We had a lot of students at Emory University that were very against it. The administration was a little bit hesitant to speak out against it, though, because of course they were concerned about their funding. We had some professors that were, advocating against it, with the fear in mind of potentially, getting in trouble with the administration. But they did have a walkout day on Emory University's campus on February 8th, where they encouraged students and professors to walk out and show their opposition to the sanctuary campus bill. Now, it was just on the campus, but it sent a pretty good signal to the administration that the students were very adamantly against this bill, and they were encouraging the administration to take a stance against it because they hadn't actually said anything once the bill had been introduced. Another thing that happened around the sanctuary campus bill is we had some professors from Emory University and some other private universities that actually walked into a Board of Regents meeting and actually literally interrupted the meeting and had their undocumented students hand deliver Valentine's Day cards, because it was on Valentine's Day, and talk about, why they as professors really care about their students and why the Board of Regents and the state of Georgia should not try to get in the way of students trying to access higher education. For those of you that are not familiar with Georgia, in the past couple of years, the state has cracked down on undocumented students being able to access education. They've already been blocked from the top 3 universities in the state. They're required to pay out-of-state tuition, and now with this anti-sanctuary bill, they would also potentially be prohibited from attending private universities because of the kinds of policies that these universities are now not allowed to enact. So that was one of the really big bills that we worked on this year. In addition to that one, I would say the most dangerous one that we've seen in the last couple of years is the non-citizen registry. Now, in its core, what it's doing is, it's a pretty long bill, but what it's trying to do is create a new state definition of domestic terrorism, which is broader than the federal definition. It also gives law enforcement the authority to track suspected terrorists and report them to the Georgia Bureau of Investigation. But then more so, what it's doing is creating a public registry of any non-citizen who has committed a crime and posting it on the Georgia Bureau of Investigation website for anybody to access. Now, the 2 parts of the bill, the domestic terrorism and the non-citizen registry, were actually 2 separate bills that got smashed together on the last day of the session because we were fighting them on 2 different ends. And at the very last minute, the House and the Senate, compromised and got them passed through at the last minute because of all the politicking that was happening. For the non-citizen registry, we've seen so much, so many people speaking out against it, but it unfortunately did not work, and the governor signed it into law actually just on Monday. So it's only been a few days since he signed it, and we are very much concerned for what the implications for this bill will be, but we are exploring other avenues of resisting and figuring out what it is we can do to address this moving forward. Next slide, please. So those were the bills that we worked on a state level. When it comes to local policies and enforcement, there have been a few things that we're working here on in Georgia. Something that we weren't directly involved in, but some of our community partners worked on, was the non-detainer policy in the city of Clarkston. So for those of you who are not familiar with the city of Clarkston, it is one of the refugee resettlement sites in Georgia. More than 50% of the population of Clarkston is foreign-born. And so it is a pretty welcoming city, but in response to the Somali deportations that have been happening, a lot of the community members looked into this idea of passing a non-detainer policy. Now, there were individuals picked up that were part of the community, and those family members were very concerned about what they could do to protect themselves and their other friends and family from getting picked up in the future. And so our friends at Women Watch Africa and the Somali American Community Center really pushed this the city of Clarkson, the council, to meet and pass this non-detainer policy. So they did a really great job of bringing in community members and community organizations to testify on behalf of this non-detainer policy, and actually did get it passed last week. So, you know, as it's written right now, and they also worked with Project South, which was great. They did a great job in drafting the legal side of it. Right now, the clerks will not honor detain requests unless ICE actually has a warrant. So, you know, although it's not perfect, it does go a long way in assuring, you know, the community members that the not going to be with ICE, and it gave a little bit confidence back for the citizens, but it's still not going in the way of becoming a sanctuary city. Now, also related to raids and enforcement, we saw a lot of uproar in the community once the raids started happening. People weren't sure, you know, what ICE looked like. They were confusing them with law enforcement, and so we thought it was best to just go ahead and provide Know Your Rights materials to all community members, regardless of if ICE was going to be in that area or have ever been in that area. So with our partners to create Know Your Rights, 23 different languages. You can see a couple of them on the screen here. But we created them in all kinds of different languages, Asian languages and African languages that we find prevalent in the refugee community, because we thought it was important to give these out to the community members so that they could, you know, slide it under the door in case law enforcement comes knocking or if ICE comes knocking. Right after the raid started happening, we started a series of canvases, and we went door to door in immigrant-heavy apartment complexes to businesses and surrounding restaurants, and actually passed these cards out and explained to people what they can do if something happens. You know, we were trying to develop a rapid response network around the raids, but it was very difficult because a lot of people were still confused about, you know, is this actually ICE? We were getting reports of just, you know, law enforcement coming. So this was our first step in addressing that and making sure that the people themselves were equipped with the right kind of information they needed in order to, you know, actually deal with an ICE official. Next slide, please. And then another resource that we've had for resisting has been with our coalition of organizations. So everything from our policy work to our Know Your Rights materials has been, a big part of that has been our coalition, which is the Georgia Immigrant Alliance for Civic Empowerment. We have 27 different immigrant and people of color organizations that make up our coalition, and that has been really helpful in providing information to the smaller communities that we may not have immediate access to. So they're able to deliver that information on our behalf to the smaller pockets of groups that you know, may not be actively looking for this information. So they were very helpful in our sign-on letters and our action alerts, and have been able to provide in-language access to a lot of the community members that need, you know, certain materials. Also with that, we do a lot of citizen lobbying and joint lobby days. We work with the ACLU quite a bit. We did a joint ACLU Advancing Justice lobby day around the anti-protesting bills that we saw this year in the state legislature. And it's just another one of our resistance strategies to show the state legislature that, you know, if you come after one of our groups, you're really coming after us all. Next slide, please. As I mentioned before, another one of our strategies for resistance has been with our businesses. So, you know, we have a fairly good relationship with our local chambers, with our ethnic chambers, and with businesses themselves. They have been great spokespersons for us when we actually do go and testify at the Capitol. Everything from, you know, helping us to kill the driver's licenses bills to the remittances bill, they have been pretty good supporters of us, and we are still working to build better relationships with them when it comes to a lot of the other bills surrounding immigrant and workers' rights. The last thing, and I'm sure a lot of the other organizations and people on this call all do a lot of community organizing, so I just wanted to bring that back up and show that, you know, within our coalitions, within our businesses, we also rely a lot on our community organizing efforts and bringing people to the rallies and to the and bringing issues to their attention that need actions taken for them. So, you know, I'm happy to take questions later on, but that's all for me in Georgia.
Hey everyone, this is Van Nguyen. I'm the Napaba Law Foundation Community Law Fellow at Advancing Justice Chicago. So given what's happening at the federal level, in Chicago, we have really shifted our policy advocacy and community organizing focus towards local and state policies that protect our communities. There are concrete policies that local and state government can put in place to protect vulnerable communities during this time, more than just mere lip service of support that we're hearing from a lot of cities. So for our legislative outreach, it is important for us to emphasize to local legislators that the 10th Amendment of the Constitution empower municipalities and states to challenge federal actions, especially those that we've seen that are xenophobic and racist. Meanwhile, legislators also need to reevaluate city and state policies that criminalize people of color. Next slide, please. So amending Chicago's Welcoming City Ordinance and passing the Illinois Trust Act are two of the policy priorities community organizations are leading to address immigration and the intersection of criminal justice. Chicago's Welcoming City Ordinance and similarly the Trust Act are pieces of these efforts that are commonly dubbed the sanctuary city policies. Recently, we've heard a lot from Attorney General Jeff Sessions scrutinizing sanctuary cities. For the general public, there's a lot of misunderstanding about what is a sanctuary city. So immigrant rights activists have really pushed back on the use of the term because it connotes to people that Chicago's Welcoming City policy will somehow shield them from ICE's reach or bar ICE from entering the city. And we know that none of this is true. During immigration raids, there's very little that city and state government can do. However, what city and states can do is stop facilitating the deportation process. Next slide. So I'll just briefly describe what Chicago's policy does. As it stands, the Welcoming City Ordinance prohibits police officers from detaining individuals for immigration-related offenses. It prohibits the Chicago Police Department from informing ICE release of an inmate and bar police officers and city employees from threatening individuals based on their immigration status, among other things. But one of the most troubling aspects of the Chicago's Welcoming City Ordinance is that there are categories of individuals exempted from protection. These categories are broad. They include people with past convictions, individuals who are defendant in a criminal case, individuals who are tagged in a gang database. So therefore, if a police officer pulls someone over and there's an immigration detainer on them, the individual falls within the category stated, police officers can then take that individual in and transfer them over to ICE. It's ironic given that the mayor of Chicago touts Chicago as the most immigrant-friendly city in the world, but there are a lot of questions for community members as to why immigrants with past criminal records or current charges are treated differently from all citizens. So our current effort is to amend the Welcoming City Ordinance to remove these categories of exceptions and to protect all immigrants regardless of past criminal records. One note that I would like to make about the gang database is that there is this growing national movement scrutinizing local law enforcement's use of the gang database. There's no process as to how someone gets on the gang database. The information in the database is usually stale and uncorroborated. The database is also shared with ICE. One of our community partners, Organized Communities Against Deportation, or OCAD, recently sued the Chicago Police Department and the City of Chicago for putting one of its members in a gang database. That information, ICE then used that information during one of its immigration raids to pick up the individual. And the individual has never been involved in a gang, but was actually a victim of a gang drive-by shooting. Next slide, please. So likewise, the Illinois Trust Act seeks to end local law enforcement collaboration with ICE, especially with regards to barring police and sheriff's departments from entering into agreements with ICE. If you think about it, there are about 55,000 immigration enforcement agents in the Department of Homeland Security and around 1 million local law enforcement officers in the United States. So the repercussions of local law enforcement acting as immigration enforcers would be tremendously damaging for our community. So for us, the Trust Act has been passed out of the state Senate, and now we're engaging with legislators on the House side. In addition to further separating police collaboration with ICE, in response to the executive orders, proposals in the Welcoming City Ordinance and the Trust Act include measures to ensure that there's an expedited response for U visa and T visa certification for victims of abuse. It bars local government's participation in any type of discriminatory registry based on race or religion. And it prohibits law enforcement agents from making arrests in sensitive areas, sort of what was mentioned earlier, such as schools, health institutions, courthouses. Next slide, please. And then furthermore, I just want to place this effort in light of changing policy priorities in the immigrant rights movement in Chicago, to focus on policies that decriminalize, Black and Brown communities, and to be more intentional with building power with Black-led organizations. After the November election, as many immigrant rights organizations discussed the need for sanctuary, Black-led organizations and many community members expressed that in Chicago, it's not a sanctuary for Black people. Since then, we've made concerted efforts to build coalition and to define what it means for all of our communities to be safe from immigration raids, safety in school, secure housing, services that serve the community's needs. I'd like to uplift one of the work here from our community partners, OCAD and Chicago's Black Youth Project 100, which have done to challenge Asian Americans in our community and those in the immigrant rights movement to rethink what sanctuary means. OCAD and BYP 100 are leading the expanded sanctuary campaign, bringing together efforts by Black and Brown communities. The expanded sanctuary campaign includes measures to decriminalize Black communities, eliminate the use of the gang database, and to defund the police and reinvest in community institutions. I think moving forward, this policy platform will lead many of the organizing efforts in Chicago. Next slide. So I think more broadly, just for movement building, I think the current administration has really forced this question of where do we draw the line, or how some folks have put it is how big is the circle of protection. At Advancing Justice Chicago, we've been challenging ourselves to sort of shed the scarcity mentality and build into the community education this idea of abundance amongst us. I think we want to try to promote across communities that collective resistance will yield collective abundance. Next slide. So our model of resistance is to build solidarity across different communities on different issues, centering it on the experiences of those who are most affected, and reframing our understanding of issues based on those lived experiences. Furthermore, I'd just like to add that coalitions are thinking through even beyond this moment that we're in and how to push for measures that aren't just defensive and reactionary, but for us to reimagine what our community would look like. And a point that I'd just like to echo what Aisha had just said, community organizers are doing a lot to bring members new to organizing. Organizers are developing and providing a lot of the analysis, training materials, and skill building exercise to assist individuals. So I definitely encourage people to get involved in their local organizing efforts. For me, I think strong resistance in this moment is going to take a lot of people from different backgrounds to utilize different skills. So there's an existing toolbox of tried and tested organizing approaches, but then there are also new ideas that we need to come up with to adapt to this time. Next slide. But that's all I have. Thank you.
Hi there, this is Angela Chan again from Advancing Justice Asian Law Caucus in San Francisco. I'll talk quickly about the model of resistance in California, and it's been great to hear about what's been happening in Georgia and Chicago and Illinois. In California, we have a couple laws that we passed through many years of organizing, and I think the good thing is that although folks not in California might be thinking, well, you guys are in this super progressive state, so you're very lucky. I think the good thing is that we develop models that we are hoping that other states and counties can adopt. And so the Trust Act in California that took us about 3 years to pass was passed in 2013, went into effect January 1st, 2014. After it was passed, in addition to some federal court decisions that helped us, about 350 jurisdictions and counting have adopted similar policies throughout the country, including some blue islands and red states. So we want to just encourage other folks to think about that. So the Trust Act, it limits ICE holds, and as we've talked about before, ICE holds are requests from ICE to local law enforcement to hold people for extra time purely so that ICE can pick up an individual and detain them for immigration purposes. There are some exceptions in the Trust Act for felonies and certain other crimes. However, the good thing is that we put in the bill that it's the floor and not the ceiling, so that local jurisdictions can adopt stronger policies than the state standard. After a federal court decision came down in April of 2014 called Miranda Olivares versus Clackamas County, that found that ICE holds violate the Fourth Amendment of the Constitution because they are not warrants based on that are signed by a judge based on a probable cause finding. We wrote a letter to all the jurisdictions in California and told them about the new federal case law, and then most counties in California adopted a policy of not responding to any ICE hold requests, and this includes some counties that are very conservative. Next slide, please. And then last year we passed the Truth Act in California, and this dealt with the criminal alien program, which is active in most jurisdictions throughout the country, and that's where ICE gets access to a jail to interview people in the jail, to ask about their immigration status, to try to coerce people into signing away their due process rights, and sign these things called voluntary departure forms. So what the Truth Act does is that the Truth Act requires that when local law enforcement receives an ICE hold, notification, or transfer request, which are now all contained in one form, I-247A form. They must provide a copy of that form to the individual, and they also must let that person know if they're going to decide to respond to that request. Another piece of the Truth Act is that it does require that local law enforcement provide a consent form to any individual it decides to give access to interview, and it certainly doesn't require local law enforcement give access. It just says that if local law enforcement decides to give access to ICE to interview an individual, they must first provide a written consent form, and that consent form lets the individual know the purpose of the interview, that's with ICE, not local law enforcement, that it's voluntary, and also that they can decline the interview. Another piece in here is that if they decide to accept the interview, that they can have their attorney present if they have one. The form has to be translated into a number of languages, and we borrowed this idea from Rikers Island, New York, where they had a similar policy that then resulted in a drastic decrease in the number of ICE interviews that occurred. Another piece is transparency. Any communications between local law enforcement and ICE, any records related to ICE access are public records subject to the Public Records Act. And lastly, the local legislative body, a city council or a board of supervisors, will have to hold a community forum every year detailing their local law enforcement collaboration or entanglement with ICE on an annual basis if there is any entanglement. Next slide, please. And lastly, I'd like to talk about the California Values Act. This is a pending bill. It's following a parallel track to the Illinois Trust Act, so we're all supporting one another and hoping all these great pro-immigrant policies pass. SB 54 effectively creates a wall between California and ICE that prohibits all ICE holds, most ICE transfer requests, most ICE notification requests. It doesn't allow ICE or CBP, Customs and Border Protection, access to a jail unless they have a judicial warrant. It prohibits using a CBP or ICE as interpreters for local law enforcement. I'm going to jump ahead here to a couple of things. It prohibits any future or current 287G agreements whereby local law enforcement is deputized and trained to act as ICE agents. So it prohibits all of that. It also would prohibit any ICE notification requests, except for with some exceptions to both local jails and state prisons. It's also important to highlight that for a lot of policies that are happening in various counties and states throughout the country, they only apply to local jails and not to state prisons, so it's important that we try our best to kind of cover both of it politically possible. And lastly, SB 54 creates safe spaces. It requires that schools, health facilities, libraries, and courthouses adopt model policies that will be developed by the California Attorney General's Office that would limit ICE and CBP access to the fullest extent under federal and state law. Next slide, please. And so it would be really great to get support from you in supporting SB 54. So individuals can sign a petition that's available here at this link online, a Credo Action petition for SB 54. Organizations can submit a support letter for SB 54. All of this is available on our iceoutofca.org website, iceoutofca.org website. And then we also developed a model policy for counties and states to adopt that's really based off of, I think, the Chicago Welcoming Ordinance, the San Francisco Sanctuary Ordinance, and also the California Values Act. And that's also available on iceoutofca.org. And there's also a toolkit that we developed that explains how we passed the Trust Act in California and encourages other jurisdictions to do the same. Next slide, please. So that's it for me. I think this is where we open it up for questions, and we're really curious to hear your guys' thoughts and your questions.
Hi everyone, thanks to all our speakers for their presentation. So now we'll open it up to questions. If you'd like to ask a question, please type it into the chat box, or you can also use the questions function as well. All right, well, if you find that you have questions after this webinar is over, I've included some contact information for our speakers today. Thank you so much for joining us, and please don't hesitate to reach out if you have any questions. Thank you.